Protocol that was just established.
I, together with Mr. Nekwa and Ms. Shivotoka, appear for the second and third respondents on the instructions of Andreas Hamoniela, legal practitioners.
Your Ladyship and Your Lordship, Mr. Gaib, Kazondana and myself continue acting for the fifth respondent.
Thank you. Thank you, Counsel. Good morning. This matter was adjourned until today for purposes of the ruling. Now, under normal circumstances, the court would just pronounce the ruling and hand the judgment down. But because this matter is of such national importance, and it is of importance to the public to know the reasoning of the court in reaching its decision, the court will read the ruling into the record. So this is going to take a few minutes. The court will then proceed to read it into the record. This is a judgment of the court. Introduction. To suggest that this matter may be viewed from the prism of lack of deserving of expedient adjudication and finalization by this court is a misstatement. The court is alive to the fact that this matter ought to be heard expeditiously and finalized before 21 March 2025. The applicant mounted a two-pronged challenge to the presidential and National Assembly elections conducted on 27 to 30 November 2024. In keeping with the provisions of the Electoral Act, the applicant challenged the conduct of the election of the members of the National Assembly in this court, while the challenge to the presidential election was filed in the Supreme Court. In terms of Section 172 of the Act, the Supreme Court is the court of first instance and final recourse, as contemplated in Article 79, Sub 2 of the National Constitution, and any challenge to the election of the President. In both applications, the applicant challenges the lawfulness of Proclamation Number 34 of 2024, which, at face value, appears to be the primary relief sought. The Supreme Court has set down the hearing for the challenge of the presidential election on 10 February 2025. Against the backdrop of the said relief, this court on 14 January 2025 notified the parties to address it on why this matter should not be stayed pending finalization of the application filed in the Supreme Court. The parties duly obliged as expected, and the court expresses its gratitude for the arguments ably raised. The issue of the stay of proceedings raised by the court Miramoto is what forms the subject matter of this ruling. The applicant and eighth respondent contended that the present application must be stayed, while the first, second, third, and fifth respondents argued the contrary, namely that the application should not be stayed but should be heard outright. The court is now ceased with the determination of the issue. Parties and legal representation. The applicant is the Independent Patriots for Change, a political party that is duly registered as such in terms of the Act and participated in both elections for members of the National Assembly and President. The applicant shall be referred to as IPC. The first respondent is the President of the Republic of Namibia, duly elected as such in terms of the Namibian Constitution. The first respondent shall be referred to as the President. The second respondent is the Electoral Commission of Namibia, established under Section 2 of the Act, and is the exclusive authority for conduct of elections under the Act. The second respondent shall be referred to as ECN. The third respondent is the Chief Electoral Officer, duly appointed in terms of the Act, and further serves as the Executive Officer of the ECN. The third respondent will be referred to as the CEO. The fourth respondent is the Attorney General of the Republic of Namibia, duly appointed as such in terms of the Constitution. The fifth to the 24th respondents are duly registered political parties that contest the election for members of the National Assembly. For reasons that will become apparent from the ruling, as the ruling unfolds, specific mention of the 5th and the 8th respondents is necessary. Therefore, the 5th respondent shall be referred to as SWAPO, while the 8th respondent will be referred to as LPM. The 25th and 26th respondents are respective ministers duly appointed as such and cited herein for the interest they might have in the matter. Applicant is represented by Mr. Katz, SC, while Mr. Heathcote, SC, represents the President, Mr. Narib represents the ECN and the CEO, Mr. Namanje represents SWAPO, and Mr. Kauta represents LPM. The application by IPC is opposed by the President, the ECN, the CEO, and SWAPO. Strictly speaking, therefore, the President, ECN, CEO, and SWAPO are the respondents in the true sense of the word, and thus, when it becomes necessary to refer to the President, ECN, CEO, and SWAPO jointly, they shall be referred to as the respondents. When necessary to refer to IPC and the respondents jointly, they shall be referred to as the parties. LPM filed an application to be joined as the second applicant in the election challenge before this court. This joinder application is to be heard in due course. LPM is also cited by IPC in this matter as the 8th respondent. Given the exceptional nature of this matter, the immense public interest involved, and the lack of significant prejudice that could be caused to the parties as a consequence, the court opted to hear Mr. Kauta as well on the question of the stay of proceedings. This approach should not, by any stretch of the imagination, be construed to constitute a view or stand adopted by the court on LPM's joinder application. This is because the court has not yet heard the joinder application. Arguments in brief. Mr. Katz argued that Section 167 of Sub 2 of the Act, read with Article 78 Sub 4 of the Constitution, recognizes that this court has an inherent power to regulate its own processes. On this premise, submitted Mr. Katz, the court has inherent jurisdiction to stay the hearing of this matter pending the finalization of the challenge in the Supreme Court on the consideration of justice in equity. Mr. Katz argued further that the factual substratum and the legal challenge in this matter and the one filed against the presidential election in the Supreme Court are the same. He submitted that both challenges are primarily directed against the lawfulness of the Proclamation 34 of 2024, the proclamation. He contended that as the Supreme Court is required to determine the lawfulness of the proclamation after hearing arguments on 10 February 2025, it would be undesirable for this court to determine the same legal issue pending before the Supreme Court. He stressed that the decision for the Supreme Court may render the proceedings in this matter either unnecessary or narrow the issues for consideration. Mr. Kauta also argued in support of an order to stay the proceedings. He made common cause with the above arguments advanced by Mr. Katz. Efficiently and cost effectively. He referred to in paragraph 19 that the context of the court's general power to stay proceedings must be exercised with due regard to the overriding objective to deal with matters expeditiously and fairly. He submitted that the court should order a stay of the proceedings pending the determination of the challenge in the Supreme Court. Mr. Heathcote argued contrariwise. He argued that the Act prohibits a stay of proceedings in election matters. He expounded on the argument by submitting that the concern that concerning that scheme of the Act is to ensure a speedy resolution of the dispute by this court. Staying the proceedings would delay the result which the masses eagerly awaits. He, however, acknowledged that this court has inherent jurisdiction to stay proceedings, but contended that such jurisdiction can only be exercised in exceptional circumstances upon the onus being discharged by the IPC. He reiterated that a stay in this matter would be contrary to the said scheme of the Act. He placed reliance on the judgment of the Supreme Court of Oliver versus Oosthuizen and another. He emphasized that the court has no inherent jurisdiction to do what offends a statute in reference to an action that may run contrary to resolving disputes speedily. Mr. Heathcote further argued that the court's inherent jurisdiction can only be exercised where there is a lacuna in the Act, but in the Act there is no such lacuna because the stay is prohibited in terms of the Act. He submitted that at the promulgation of the Act, the legislator was alive to the fact that where there is a challenge to both the election of the members of the National Assembly and the presidential election, the challenge would likely be similar in nature, based on the same facts and constituting the same complaints. The legislator, nevertheless, saw it fit that the said challenge be heard in two different courts without providing for a stay of one of the challenges to await the outcome of the other. He invited the court not to stay the proceedings and to order that the hearing on the merits of the application proceeds. Mr. Narib aligned himself with the arguments raised by Mr. Heathcote and equally submitted that the court should not stay the proceedings. Mr. Namanje also aligned himself with the arguments presented by Mr. Heathcote and presented the following additional arguments. He commenced his argument by stating that a stay of the proceedings amount to a refusal of the court to hear and determine the dispute between the parties. He submitted that the court is obliged to, by law, to hear any matter that falls within its jurisdiction and has no power to exercise a discretion to decline to hear such a matter for the reason that another court has concurrent jurisdiction. He submitted that it would be irregular to stay the current proceedings. On this score, he referred to a decision of the Supreme Court of Appeal of South Africa of the Standard Bank of SA Limited and others versus Tobinyane and others, and Standard Bank of SA Limited versus Girana NO and another, where it was remarked that, and I quote from paragraph 27, "It is law of long standing that when a high court has a matter before it that could have been brought in a magistrate court, it has no power to refuse to hear the matter." Paragraph 30, "A high court should hear a matter properly before it and within its jurisdiction, and that if a magistrate court also has jurisdiction and a matter could be dealt with less expensively in that court, the High Court can discourage litigation before it by an appropriate order regarding cost." End of quote. Mr. Namanje further argued that another reason why a stay of prosecution should not be ordered in this case why a stay of proceedings should not be ordered in this case is that the Supreme Court would also benefit from the reasoning of the subordinate court. Mr. Namanje argued that the only document in this matter that forms part of the application pending before the Supreme Court is a notice of motion from which similar facts to the current matter cannot be deduced. He submitted that the delay in dealing with and determining this application prejudices SWAPO as it won the elections and had to put plans in place to govern the country. He magniloquently submitted that if the court stays the proceedings, it would be abdicating its powers and would be shying away from the matter. Furthermore, this court would demonstrate that it is not independent as it fears that it may be found to have made a wrong decision, and this would undermine the hard-fought democracy of our country. He called on the court not to stay the proceedings. In reply, Mr. Katz submitted that IPC intended to have the matter heard speedily, but in light of the similar challenge pending in the Supreme Court, it would be just and equitable to stay the proceedings in this court. He argued that no onus rests on IPC to prove the sustainability of the stay, as it never applied for the stay of proceedings. He, however, submitted that the striking similarity in the primary relief sought in both courts make it compelling for the present proceedings to be stayed pending the determination of the presidential election challenge. Mr. Katz submitted that the proceedings with this matter would delay the resolution of the dispute between the parties and unnecessarily waste cost, time and judicial resources, as this court would listen to the arguments and rule on the lawfulness of the proclamation, while the same determination is due to be made by the Supreme Court in a short period of time. He concluded his submissions by stating that the ruling by this court would be subject to appeal to the Supreme Court, which is already seized with the determination of the same matter. Analysis and decision of inherent jurisdiction. The court, a division of the High Court of Namibia, is established in terms of Section 167 of the Act. In terms of Section 167, subsection 2 of the Act, the court has, in the exercise of its powers and in the performance of its functions, all the powers of the High Court confirmed by Articles 78 sub 4 and 80 of the Namibian Constitution and the High Court Act 16 of 1990. Article 80 of the Constitution provides as follows under sub-article 2, and I quote, "The High Court shall have original jurisdiction to hear and adjudicate upon all disputes and criminal prosecutions, including cases which involves the interpretation, implementation, and upholding of the Constitution and the fundamental rights and freedoms guaranteed thereunder." End of quote. Article 78 sub 4 of the Constitution, on the other hand, provides that, and I quote, "The Supreme Court and the High Court shall have inherent jurisdiction which vested in the Supreme Court of Southwest Africa immediately prior to the date of independence, including the power to regulate their own procedures and to make court rules for that purpose." End of quote. Article 78 sub 4 acknowledges that the High Court possesses inherent power to regulate its own processes. Where Taylor J., in Prosecutor General versus Miguel and others, had occasion to consider the inherent jurisdiction of the High Court and remarked as follows at paragraph 32, and I quote, "I have above come to the conclusion that this court has inherent jurisdiction to make any order which the law does not prohibit it to make whenever it is just or equitable to do so, and in particular to ensure the observance of due process of law and to do justice between the parties and to secure a fair trial between them." End of quote. The High Court retains inherent jurisdiction to make any order that it deemed just and not prohibited by law. The order should be in the interest of justice. This is necessary in order to ensure due process of law, provided that such an order does not contradict the relevant statute. With respect to the exercise of inherent jurisdiction based on equity, courts do not act on hypothetical ideas of justice and equity, but when they invoke their inherent jurisdiction based on equity, it will be in accordance with the principles of law. This resonates with the remarks made by Ines C.J. a century ago in Kent versus Transvaalisch Bank, but which are still alive to date, when he stated as follows, and I quote, "He, the appellant, also asked us to stay proceedings on equitable grounds, urging that we had an equitable jurisdiction under the insolvency law. The court has again and again had occasion to point out that it does not administer a system of equity as distinct from the system of law. Using the word do so in accordance with those principles, we cannot do so at all. Mahinga J.A. in the Supreme Court judgment of Bankvintek versus Mufuka discussed the principle of equity and cited with approval the following remarks by Kotze J.A. that the error in the transfer deed must be rectified. In the earlier case of Mills and Son versus Benjamin Brothers, 1876, Bush at 121, the same learned judge observed, "Now it is quite true that this court is a court of equity only as far as it is consistent with the principles of the Roman Dutch law. This qualification is of importance, for equity cannot and does not override a clear provision of our law. Our common law, based to great extent on the civil law, contains many an equitable principle, but equity, as distinct from opposed to the law, does not prevail with us. Equitable principles are only enforced in so far as they have become authoritatively incorporated and recognized as rules of positive law. It is true that the Roman jurists laid down in omnibus sit valde maxim in jure aquitas spectanda sit, but Bronkhorst and the other civilians who have written special commentaries on this particular title point out, where the law in particular instances is clear, it must be observed, although it may seem to the contrary, to be contrary to considerations of equity. Hence, it is a maxim with the commentators that non omne quod licitum honestum est. End of quote. In our view, there can be no doubt about the inherent powers of the High Court, that the High Court possesses, which can be invoked on the basis of justice. Similarly, this court, by virtue of Section 167, sub 2 of the Act, has equal inherent jurisdiction. Inherent jurisdiction, however, cannot be invoked on the basis of equity alone, distinct from the principles of law. For what it is worth, Mr. Katz, Mr. Kauta, and Mr. Heathcote are ad idem, and correctly so, that this court has such an inherent jurisdiction to regulate its own processes. The said council could, however, not find each other on whether or not the facts of this matter are such that they create fertile ground for the court to invoke the inherent jurisdiction to stay the proceedings pending finalization of the challenge to the presidential election in the Supreme Court. The application placed before it. It should be mentioned that generally it is within the powers of the High Court to merimoto raise a question to be addressed by the parties, including a question of whether or not it would be in the interest of justice or to prevent an abuse of process to postpone a matter. This is because the High Court has inherent jurisdiction to regulate its own processes and proceedings and to also ensure the fair administration of justice. The court's discretion to act merimoto is anchored in common law, supported by procedural rules and case law. The High Court's power to postpone matters merimoto is necessary to ensure that the interests of justice are upheld and to prevent the misuse of the judicial process. There is, therefore, nothing untoward with the approach adopted by this court to merimoto invite the parties to make a representation on whether or not this matter must be stayed pending the challenge in the Supreme Court. Stay of proceedings. As stated above, the court issued a notice to the parties to address it on whether or not these proceedings should be stayed pending the finalization of the challenge to the presidential election in the Supreme Court. In order to appreciate the genesis of the notice served on the parties, it is deemed necessary to have regard to the relief sought in both motion in the Supreme Court and this court. In the notice of motion filed by in this court against the election of the members of the National Assembly, IBC seeks the following relief, and I quote, 1. Declaring proclamation number 34 of 2024 in violation of Article 46 sub 2 of the Constitution of the Republic of Namibia and in contravention of Section 64(3)(b) of the Electoral Act 5 of 2014. Declaring the first respondent schedule to Proclamation 34 of 2024 in violation of Article 46(1)(a) of the Constitution of Namibia and in contravention with Sections 89(1) of the National Assembly, inconsistent with and invalid in purposes of Schedule 4, Sub 1 of the Constitution of the Republic of Namibia and inconsistent with and invalid for purposes of Section 64(3)(b) of the Electoral Act 5 of 2014. 4. Declaring the conduct of the election of for members of the National Assembly in breach of the principles of Part 5 of the Electoral Act 5 of 2014, including return and outcome, and setting aside as unlawful and invalid. 5. Cost of 1 instructing and 2 instructed counsel where employed. Further and final relief. In the challenge lodged in the Supreme Court against the election of the President, the following orders are sought by IPC. 1, and I quote, 1. Declaring proclamation number 34 of 2024 in violation of the Constitution of the Republic of Namibia and in breach of the principles of Part 5 of the Electoral Act 5 of 2014, and as such unlawful and invalid, setting same aside. 2. Declaring the 2024 presidential election to have been conducted in breach of the Constitution of the Republic of Namibia and as not in accordance with principles of Part 5 of the Electoral Act 5 of 2014. 3. Declaring the returns and outcome of the 2024 presidential election invalid, unlawful, and setting same aside. 4. Ordering the conduct of a fresh presidential election in accordance with the Constitution and the Electoral Act 5 of 2014. 5. Cost of the application, including cost of 1 instructing and 2 instructed counsel where employed. 6. Further and or alternative relief. End of quote. Several questions were raised on whether or not the court has the power to stay these proceedings. Mr. Namanje argued with force and might as he at his command that the court lacked the authority to stay these proceedings. He argued that in order to stay the proceedings will result in the court refusing to hear the parties. He pulled no punches and argued that any attempt to stay the proceedings by this court will constitute abdication of its duties, would be tantamount to the court shying away from carrying out its functions, and would demonstrate that this court is not independent. This, he submitted, would be plainly irregular. A stay of proceedings, he maintained, would undermine our hard-fought democracy. Mr. Namanje, for his contentions that this court has no authority to refuse to hear a matter, relied on the decision of Standard Bank of SA Limited and others, Supra, referred to Supra. The facts of this matter are that the application by several banks were made against debtors who failed to service their mortgage bonds and had purchased motor vehicles on credit and defaulted on payment. The debtors failed to oppose the claims, and their matters were enrolled in the unopposed motion court. Orders were sought for repayment of outstanding indebtedness and for leave to specially execute on mortgaged residential properties. on the basis of concerns that the role of the High Court were being congested by matters which could have been heard in the Magistrate Court, and there were many matters which could have been heard in the local seat of the Johannesburg, which is clogging up the role in Pretoria. The High Court found that for banks to institute proceedings in the High Court when Magistrate Court has concurrent jurisdiction was an abuse of court process. It further found that there is no obligation on the High Court to entertain matters that fall under the jurisdiction of the Magistrate Court. On matters where the local division is the more appropriate forum for hearing, the High Court found that the court hearing the matter may mere motu transfer such a matter to that court. On appeal, the Supreme Court found that when a High Court has a matter placed before it that falls within its jurisdiction and that could have been brought in the Magistrate Court, it has no power to refuse to hear that. Similarly, the Supreme Court found that it was not open to the High Court to decline to hear any matter over which it has jurisdiction, and no abuse of process exists on the part of the plaintiff who adopted the or who opted to institute proceedings in the High Court. The above facts in the Standard Bank case are miles apart from the present matter. Firstly, in the Standard Bank matter, the Supreme Court found that the High Court was obliged to adjudicate upon proceedings from the Magistrates Court and other matters from another local division, which the High Court had the necessary jurisdiction over. The High Court was obliged to hear such matters, notwithstanding the fact that the other court had concurrent jurisdiction over such matters, and they were congesting its role. In the present matter, there is no question of the stay of proceedings under discussion being premised on any allegation of congesting this court's role. Secondly, and significantly, the stay of proceedings forming the subject of the present case, it's not a permanent stay of proceedings, but a temporary stay pending finalization of the challenge of the presidential election in the Supreme Court. The stay in the Standard Bank case was a permanent stay. Therefore, the authority does not assist Mr. Namanje. Frank AJA in Olivier, referred to Supra, said the following regarding the temporary stay of proceedings, and I quote from paragraph 23. It is not necessary for the purposes of this judgment to spell out the circumstances in detail that would lead to the High Court granting such stay of proceedings. It is, however, necessary to refer to three scenarios relating to the abuse of court process. Paragraph 24. Firstly, there is what amounts to a permanent stay, i.e., an order staying proceedings permanently where, for example, the litigation is held to be frivolous and vexatious. The party against whom such an order is given cannot proceed with such process and is permanently barred from obtaining such relief against the other party. Paragraph 25. There is what amounts to a temporary stay. Examples of this are where litigant is prevented from continuing with the process until the cost of previous unsuccessful litigation are paid, or where civil action is stayed until criminal proceedings flowing from the same facts are finalized. These kind of stays are pointed out by Solomon J.A. are cases rather in the nature of postponement than a stay of proceedings. And there can be, of course, no question that the jurisdiction of a court of justice to postpone the hearing of a suit on application of either party. Paragraph 29. Where temporary stay is applied for, the court exercises the same jurisdiction as it would when a postponement is sought, and it goes without saying that in such circumstances, such temporary stays or postponements can be granted in the exercise of judicial discretion. To put it simply, the same discretion afforded to a court when granting or refusing postponement is afforded to a court when temporary stays are sought. End of quote. A temporary stay of proceedings pending finalization of the challenge filed in the Supreme Court is not a permanent stay of proceedings before this court. On the contrary, it is a temporary stay, which is akin to a postponement. Put differently, the court called on the parties to address it on the reasons why this matter cannot be postponed for hearing on a future date after finalization of the challenge to the presidential election pending before the Supreme Court. Any elevation of the consideration to a stay in the present matter to a higher pedestal of permanent stay of proceedings would be incorrect and unjustified on the present facts. There is no refusal to hear this matter. Instead, there is the temporary stay of the matter pending the decision of the Apex Court on an identical legal question, which the Supreme Court will determine as a matter of urgency. What is more, is that the authorities cited by Mr. Namanje refer to an actual refusal to hear a matter. This is in respect of a permanent stay of proceedings, which is foreign to this matter, as the issue under consideration is a temporary stay. The argument, therefore, that a stay of proceedings under consideration constitutes a refusal to hear them and defends our democracy is unsustainable and devoid of merit. The practice of law is about words, the choice of which must be carefully considered before being uttered. This view is by no means intended to tame legal practitioners in their arguments, but the choice of words and the language used as in casu, if engaged out of context, can have the capacity to cause an uproar or, at the very least, serve as an enticement for the masses to lose confidence in the judiciary, the rule of law, and democracy as a whole. This court is mindful of its role as the guardian of the Constitution and the rule of law. The court further cherishes democracy, which was not delivered on a silver platter, but was attained through blood, sweat, and tears of our forefathers. This court has the power to stay proceedings brought before it, either temporary or permanently. An application for a temporary stay of the proceedings should not be granted upon mere asking. Exceptional circumstances must be present for proceedings to be stayed. This is due to the fact that the court is expected to duly and expediently adjudicate upon a matter pending before it, and which is within its jurisdiction. After all, it can be accepted that the parties approach the court in search of a speedy adjudication and finalization of a matter. A court should, however, not act mechanically to finalize a matter speedily, even in the face of compelling reasons and circumstances requiring a temporary stay of proceedings for justice to be effectively and ultimately rendered. The court should, therefore, where it is in the interest of administration of justice to temporarily stay the proceedings, consider granting a stay of proceedings and, if necessary, do so out of own motion. The court, in the exercise of its inherent jurisdiction, may temporarily stay proceedings, as Frank AJA remarked in Olivier Supra at paragraph 25, where a litigant is prevented from continuing with the process until cost and previous unsuccessful litigations are paid, or where civil action is stayed until criminal proceedings arising from such facts are finalized. This list is non-exhaustive. The court may order a stay where it is clear that there is an abuse of the court process. Similarly, a court may order a stay of proceedings where it is in the interest of the administration of justice to do so. The power to stay is exercised sparingly, as courts of law are open to all, and parties should generally have matters placed before the court determined expeditiously. In order to stay the proceedings pending a hearing in another court, the issues between the parties should be same or substantially similar. Technical differences between the cause of action, although related to the same substance, may not be sufficient to rule out a stay. Is this an appropriate matter to order a stay of proceedings? Mr. Heathcote argued that the court should not invoke its inherent jurisdiction to order a stay of proceedings pending finalization of the matter in the Supreme Court because there is no lacuna in the Act, and further that such an order is prohibited by the Act. Mr. Katz and Mr. Carter, as stated above, argued to the contrary. We have considered the provisions of the Act and searched in vain for provision that expressly or impliedly prohibits the granting of an order to stay proceedings. Mr. Heathcote did not single out any provisions in the Act in support of his argument. We, however, understood him to say that the scheme of the Act is such that a challenge to the election of the members of the National Assembly launched in this court must be dealt with expeditiously. He proceeded to submit that any order issued by this court which has the capacity of delaying the hearing and the finalization of the matter would be prohibited by the Act. In our view, the above argument calls for a determination on the nature of the present matter coupled with the scheme of the Act in order to determine whether a stay of proceedings is warranted or not, and whether or not such an order, if granted, would offend the Act or its scheme. It is relatively in a relatively similar matter of Black Horse Limited, referred to Supra, where the court was faced with application to stay in the High Court pending an associated decision of the Supreme Court. Judge Waxman, sitting as a judge of the High Court, remarked that, and I quote in paragraph 9, "On any view, the Supreme Court will have to deal with arguments about cost and commission, and it is inherently unlikely that they are going to confine themselves in their pronouncement or in reaching a principled decision on the point to only the very particular facts which arose in the case of Harrison itself. Any decision made is likely, in my judgment, not only to affect what facts are truly relevant and what are truly necessary factual findings for the court to make in the context of the law on unfair relationships and then pronounced by the Supreme Court. It seems to me that where any trial judge is dealing with the PPI, Payment Protection Insurance, premiums on the question of cost and commission, which, as I have said, is a notable feature of such claims, the notion that a trial judge is unlikely to be assisted by any decision from the Supreme Court is unrealistic in the extreme. At paragraph 21, the court stated as follows: "The Supreme Court is going to consider areas of law which are effectively new for it and which will clearly encompass some of the essential issues involved in these matters, and indeed in many others of the same kind. There is obvious advantage in awaiting the Supreme Court until the Supreme Court has decided those issues. The result is likely, depending on the outcome, to dispose of some of the claims either in favor of the claimant or in favor of the defendant without a trial. It will in any event provide a proper focus basis for considering the true scope of the evidence and the factual findings which the court at first instance will be required to make." Paragraph 25. Of course, there had been some real or material prejudices as a result of the delay, other than the passage of time itself. The position might be different. There is no such evidence or submissions before me. It has not been suggested that the traditional delay is going to cause memories to fade or arguments of that kind. That would have been wholly unrealistic on the basis that if memories were to fade, they would have faded long ago before the litigation commenced. Paragraph 26. However, there is, in my judgment, a potential prejudice to Black Horse if the stay is not granted, because if it wins at first instance and then ultimately on appeal it loses, it is likely to have lost the cost of the trial and may have to pay the claimant's cost of that because of the Supreme Court ruling effectively goes against it. It is no answer to say that this is simply an inevitable risk of litigation, because there is always a prospect on appeal when there is a sensible and a proportionate route which will avoid the risk happening. That is to wait for the Supreme Court to decide before taking any further steps and therefore incurring any further costs which may prove to have been unnecessarily incurred. Indeed, the benefit assists the claimant as well, because if the Supreme Court confirms the Court of Appeal or renders all or any part of these claims viable, it is surely better for the claimant to know that now before it incurs the expenses of trial. Following any such decision, it is likely to take the sensible view that there is no point in pursuing those claims. End of quote. The above remarks are of persuasive value in consideration of the application of, inter alia, Rule 1 sub 3 of the High Court rules and the overriding objective of litigation in the High Court referred to above. This Court therefore endorsed the above remarks. We take note of Mr. Namanja's argument that SWAPO will be prejudiced by a stay of proceedings as, after winning the elections, it had to put up plans in place to govern the country. We hold the view that while it is reasonable that SWAPO would be planning to govern the country, a stay of proceedings pending the finalization of the matters scheduled to be heard in a period of 3 weeks cannot be said to cause material or substantial prejudice to SWAPO. It follows, therefore, that the prejudice to plan raised is immaterial to offend a possible stay. The right to govern is subject to the right of the disenchanted parties to challenge the election. In the present matter, the Court finds that A. It requires no magnifying glass to come to the realization that the primary challenges mounted by IPC in these proceedings and the challenges to the presidential election pending before the Supreme Court is the same. This is borne out by the first and second prayers on both notices of motion, which attack the impugned proclamation on the exact same basis. B. Although the remedy that this court may grant differ from the remedy that the Supreme Court may grant, because the challenge in this court is to the National Assembly elections as opposed to the presidential election challenge in the Supreme Court, the legal challenge is the same. A determination of legality of the proclamation would have an effect on both the presidential and the National Assembly elections. The Act makes the urgency of determination of this matter clear in the national interest, and this court remained acutely aware of its responsibility to hear and determine electoral matters. C. It is thus undesirable for this court to consider the same legal and primary issues of lawfulness of the proclamation that is presently pending before the Supreme Court in circumstances where the Supreme Court will hear argument on this issue in a period of 3 weeks on 10 February 2024. D. It is not far-fetched to remark that the decision of the Supreme Court would render guidance to this court in the present application, as the said decision may result in the proceedings before this court being unnecessary, alternatively leaving narrow issues for consideration and provide a more focused and expedient approach. E. In the event that the Supreme Court upholds the lawfulness of the proclamation, This court will not be bound. This court will be bound by that decision, and the IPC's challenge to the proclamation, as a matter of course, falls away. And if, in the same vein, if the Supreme Court finds that the proclamation is unlawful, this court will be bound by that decision and will only be required to determine the consequential remedy. This will undoubtedly save cost, time, judicial resources, and avoid a duplication of work. The above findings demonstrate that the challenge pending in the Supreme Court and the present matter before this court are inextricably linked to the extent that the finding of the Supreme Court will benefit the parties in the evaluation of their matter and stance to be adopted. The said decision of the Supreme Court will map the trajectory of the matter, albeit on a loomed path, as it would have decided the fate of the proclamation. We agree with the submissions by Mr. Katz and Mr. Carter that the decision of the Supreme Court will also render guidance to this court, ensure certainty, narrow the issues for determination, and surely expedite the resolution of the dispute between the parties. As this ruling draws closer to its conclusion, we take note of Mr. Namanja's argument that it is undesirable for this court that it is desirable for this court that this court hears and determine the present application, including the challenge to the proclamation, as the Supreme Court had always held that in matters handled by the High Court, it benefits from reasoning of that court. This argument is sound. However, given the exceptional circumstances of this matter, that the Supreme Court will hear arguments on 10 February 2025 and possibly decide on the lawfulness of the proclamation, it would be convenient, expedient, appropriate, fair, cost-effective, and provide certainty to await the determination of the lawfulness of the proclamation by the Supreme Court. Conclusion. The court holds the view that the determination of some of the issues, including those that are raised mera moto, like jurisdiction to adjudicate upon a matter, the issue of owners plays central stage in order to find out whether a relief or issue had been proven by the responsible party. In this matter, the court raised the issue of the temporary stay mera moto when none of the parties applied for a stay. We hold the view that the exceptional circumstances of this matter discussed above render the matter raised by the court to constitute an inquiry with no onus placed on any particular party. What the court assessed was whether or not there are compelling arguments to temporarily stay these proceedings. We find that Rule 1, Sub 3 of the Rules of the High Court applies to the present matter, and in keeping with the overriding objective of the rules, to facilitate the resolution of the real issues between the parties justly, efficiently, and cost-effectively. It is inevitable that the proceedings before this court ought to be stayed. Such a stay would necessitate the expeditious and fair hearing of the matter as the Supreme Court may stand for determination at a later stage. 3. The application is postponed to 20 February 2025 at 10 o'clock for a status hearing and a hearing of the joint application filed by the Landless People Movement. 4. The parties must file a joint status report on or before 13 February 2025 in respect of the status of the Supreme Court case number A2 of 2024. 5. The parties must file their respective heads of arguments as follows. A. The applicant must file on or before 13 February 2025. The respondents must file on or before 17 February 2025. The arguments to be filed is in respect of the joinder application. Just want to make that clear. 6. The amount of security fixed by this court on 15 January and payable by the applicant must be paid on or before the 11th of February 2025. This is the ruling of this court, and I hand it now down. That concludes our proceedings for today. We are adjourned.